Hi, everybody. This is Monty McIntyre. I'm glad to be with you today. And today I'm going to talk about a new civil case that came out last month dealing with the issue of arbitration. I do three things, all related to the law, civil law in California. First, I act as a neutral, as a mediator helping settle cases, and as an arbitrator and referee conducting hearings and issuing fair and impartial decisions in arbitrations and reference matters. I do this with ADR services throughout California. I'm glad to help you if you need some help in one of these areas. I also publish California case summaries, and this is a great service to lawyers in California where I provide one paragraph summaries of 50 to 100 page cases so you can keep up with all the new civil cases in your practice areas. And I also offer very unique annual publications. So, a great way to start your 2023 is to really get to know all the important 2022 cases decided last year in your practice areas, because one or several of those are going to have an impact on your existing cases. And you never know what's going to happen. You might get a case settled when you would otherwise have had to try it. You might win a summary judgment motion. So these things can make a big difference in your practice and are very helpful to lawyers. Finally, I help law firms mentor their newer, younger associates with master lawyer mentoring services. And this helps the younger lawyers learn the essential skills they need, learn how to strategically work up and present their cases so they can become excellent lawyers, getting excellent results for their clients and the firm. So today we're going to talk about this arbitration case. And in arbitration cases, it's always this issue of, was there an arbitration agreement? Was the plaintiff, who was the employee, in this case, it was an employment case, was the plaintiff who was the employee? These were plaintiffs. Did they have notice of what they were signing? Is there any dispute about authenticity of their signatures or any claim of forgery, things like that? And these are some of the regular issues because arbitration cases are decided all the time in our courts of appeal, not so often in the Supreme Court. So in this case last month, you'll see in the decision, when the defendant employer made the motion to arbitrate, the plaintiff's argument was, hey, we got a bunch of documents when we signed up to get this employment. We don't remember seeing anything or don't remember signing anything like an arbitration agreement. And the court said, that's not good enough. You weren't really claiming there was forgery. You didn't claim the dispute the authenticity. So really, that was not enough. So, I call this case the not remembering is not good enough. And so take a look at the summary of the case. I think you'll find it to be useful and instructive. And if I can help you in any of these ways that I provide services, I would be happy to help. Until we meet again in another week or so, I hope you do well and be well and stay safe and stay healthy. Bye-bye now.